This is Professor Blakey. Thanks for stopping by. This is Glenn Maven, Digital Publishing, and the topic for today's video is, what's the difference between murder and copyright? Well, it seems pretty obvious that maybe murder is a criminal case and copyright's a civil case, but what's the difference between civil and criminal? One you can go to jail, one you can't. How do you prove the case? But copyright can be a criminal case as well. By looking at these two different types of cases, we can learn a little bit about how cases work, what a remedy is, what causation is, the different kinds of remedies and defenses. So let's get started. What is the difference between murder and copyright? Are you seeking knowledge? Well, then you've come to the right place. Glenn Maven, Digital Publishing. So what is the difference between murder and copyright? Well, you might think murder is a criminal case and copyright is a civil case. But there can be criminal copyright cases. These are usually called piracy. So what are the parts of a case? Those are the elements that you have to prove. If you're the plaintiff in a copyright case, you'd have to prove a certain set of elements in order to win your case. And the burden is on the plaintiff. It's a criminal case, then it's the prosecutor's elements. Either the plaintiff's elements or the prosecutor's elements are called the case in chief. A case is the same thing as a claim, is the same thing as a cause of action. That just means that there's a harm that is recognized at law. A cause of action is a harm for which the law provides a remedy. For example, the law doesn't provide a remedy for a broken heart, but does provide a remedy if someone runs into your car. What is a criminal case? Well, it's defined as criminal because it's a harm to the community at large. So it's usually captioned something like state versus defendant, California versus Professor Blakey. What is a civil case is different because that's not a harm to the entire community. It's really an issue or dispute between a few people, such as Jones versus Smith get in a car accident. What is the remedy for the harm? Once the elements of a case are established, then the court can provide a remedy. Obviously, they can't fix a broken heart. That's probably why they don't give a remedy for broken hearts. Back in the old days, they gave a remedy for broken engagement because there was an economic harm that was recognized. Those types of cases are not recognized as causes of action anymore. The typical remedies, the three remedies that the court can give are money, an injunction, which is an order to stop doing something, like stop using a copyrighted song, or jail and prison. So those are the three things that the court can give you. They can't give you your ability to walk or fix a car that's been totaled, but they can give you money to replace those harms. And in copyright and trademark cases, they can issue injunctions against the other person using your copyright or your trademark. In a criminal case, the remedy could be going to jail or prison, and that's punishment for the harm to the community at large, whether it's a criminal copyright infringement case or a murder case. There are two kinds of defenses, as we know. The negating defense is when the plaintiff or prosecutor is missing one of the elements of the case in chief. I want to murder my ex-husband. I have the wrongful intent and I take a wrongful act. I go over to his apartment and I shoot him. I think he's sleeping on the couch and I shoot him. Well, it turns out the autopsy is performed and he's been dead for hours before I shot him. So there's no causation. The prosecutor in a murder case would have to prove causation. And in this case, yes, I intended to shoot him. I did shoot him. I intended to murder him, but I didn't, because the defense can cross off that element of the plaintiff's case. The plaintiff has to prove all of the elements of their case in order to win. The affirmative defense is a defense that has its own elements and required evidence to prove those elements. Affirmative defense is when the party has to come forward with their own evidence to prove a new or different element. So in the murder case, perhaps, you could have the defense of self-defense. This is an affirmative defense because you want to prove additional elements in order to get out of the case. Your defense requires elements and proof to be brought forward affirmatively by the defendant. A typical affirmative defense in a murder case would be self-defense. So perhaps I could claim that my ex-husband came to my apartment and he had a knife, so I shot him. So the element for affirmative defense of self-defense is that I was in reasonable fear for my life, and that I took actions that were in accord with the level of fear I had for my life. He had a knife, he lunged at me, so I shot him. I had an act that caused his death, but I also have an affirmative defense that requires additional evidence in order to prove this additional element. The elements of any case at all have sort of the same framework, which can help you if you think in terms of a metaphor, an analogy to a medical case. You have the right to be healthy, there's some sort of harm to your health, how is it caused, and how can we fix that? What remedy could the doctor give you? Most cases require causation or harm, causation of the harm, damages, and a remedy. The elements of a murder case are that there's a general right to safety in the world, and since it's a criminal case, we have these special elements that are in criminal cases: wrongful intent and wrongful act. Those usually have to occur at the same time. So you intend to kill someone, and then you take the act that causes the death of a human being. So the right, the act, the intent, the causation, and the death are the elements of a murder case. A negating defense to a murder case could be, for example, that there was no causation. There was death of a human being, but the acts of the accused person, the defendant, did not cause the death of the human being. An affirmative defense to a murder case could be that there was causation, did cause the death of a human being, but the person, the accused person, was acting in self-defense. This requires its own elements and its own evidence. So that's why it's an affirmative defense. The defendant has to come forward with evidence to prove their elements of the affirmative defense. They can't just cross off one of the elements in the prosecutor or plaintiff's case. Affirmative defense to murder is typically that the accused person was acting in self-defense, in reasonable fear for their own life. The elements of a copyright case are ownership of a copyright. Let's assume that you're the author or you're the publisher and you have the ownership of the copyright. And then very typically the elements of the copyright case are called original and copying. You have an original work of authorship, someone else copied it, there was no permission or license, so it's an unauthorized copying. The basic elements of a copyright case are original and copying. There's no element of damages. There's no requirement that the copying caused a harm in the terms of money or other damages. There could just be damages presumed, and those are given in the form of statutory damages, money, to the copyright plaintiff without having to prove that they lost profits or anything like that. So there's no element of damages. And there's also no state of mind requirement in a copyright case, meaning that the person who's accused of copyright infringement could have done it innocently. They didn't intend to copy the copyrighted work. They didn't know it was copyrighted, but they did copy an original work, so it's still copyright infringement. The interesting thing about copyright cases is it's very hard to prove copying. If the plaintiff has the burden to prove copying, how do they prove that? They can prove they have an original work, but how could they prove that the defendant actually copied? Often there's no witness to the copying, there's no documents that prove the copying. So what can happen is that you can use indirect evidence. Direct evidence is when the witness or document directly proves the element. If there is a videotape of someone shooting another person, then that proves the act that caused the harm in the murder case. What is the difference between direct evidence and indirect evidence? Direct evidence is when the evidence, for example, a witness or a document, directly proves the element that the plaintiff has to prove in their case. So the element and the evidence equal each other. Indirect evidence is when the evidence tends to prove the element, but it's not an equation. You might need additional logic, you might need additional evidence, you might have to kind of make a leap of logic or use other evidence to get from the evidence to the element that has to be proven. So that's what makes it indirect. There's some space between the evidence and the element. Indirect evidence is also called circumstantial, and that's when you have to combine logic and evidence and make an inference that leads you to the element. There's some space between the evidence and establishing that ultimate fact or element that you have to prove. So you do have to prove copying in the copyright case, but it's usually indirect evidence of copying, because often the person who's copying is on a computer somewhere else, and you don't have any direct witness or document, any direct evidence proving that element of copying. Thank you so much. This concludes today's video. What's the difference between murder and copyright?